We are joined by political analyst Tshepo Kgadima on the phone line. Good morning to you, Mr. Kgadima. Thank you so much for joining us. Tell us what your reaction is to the judgment handed down in this case between Bank Baroda versus Oakbay.
Well, I think this is certainly good news for the rule of law in South Africa and also for the constitutional scheme that we have in the country. And it's certainly to be welcomed. And I think it is really brought about the much-needed relief for the thousands of employees of the Oakbay group and to be able to give them certainty to be able to plan. But most importantly, of course, is to ensure that the Constitution can be seen to be applicable to all. And I think that the judgment really does pave the way in that regard. And more importantly, is about the impending application to be made by Oakbay in determining on whether or not the banks do have a right to be able to take the action that they have done. And I have contended for a long time that indeed the conduct of the banks is unlawful, and therefore such an application by Oakbay, I think, would help to give clarity not only to Oakbay, but to the entire corporate world of South Africa, and even, of course, foreign direct investors who I think up till now didn't have certainty and would not have been in a position to make any long-term decisions to invest, taking into account the arbitrary, unconstitutional powers that the banks seemed to be having. And the time is opportune indeed, I think, for a declaratory order for the banks to be declared public institutions or quasi-organs of state, because to do so, it would in fact remove this arbitrary power that they have been exercising over hapless citizens.
Tshepo, just to talk to us about this impending application that's coming up in December. Having this judgment passed down, what does it mean for the day-to-day functionality of Oakbay? Because I can try to imagine how a fully-fledged group of companies can try and function without banking accounts. What would it have actually meant had they not been granted the relief that they received today?
Had they not been granted the relief that they sought, the consequences would have been dire and catastrophic. And we have to be thankful that the justice in this case was done, and the judge effectively remained loyal to the law, which is what is required of all justices or judges to do. But indeed, the consequences of the results would have been dire and catastrophic, and it has really brought much relief. But it is important to take the step further, as I mentioned, to now have to approach the court on the basis of constitutionality, because we have already seen in the CPS matter with regard to the payment of social grants that CPS was correctly deemed and found to be a quasi-organ of state that had the obligation. And we have to bear in mind that banking or financial services and access to financial services and banking is at the core of the Constitution under Chapter 2, the Bill of Rights. And it is something that has to be treated very seriously, as it is a fundamental constitutional right, and it cannot be something that is arbitrarily removed from any citizen, howsoever, because to do so, in fact, their dignity would be violated, and that cannot be allowed, because the Constitution makes a specific provision and a requirement that the dignity of citizens has to be upheld. So it is important that the banks in South Africa must henceforth be declared public institutions or quasi-organs of state to ensure that we never have to have a repeat of this sorry saga we have seen Oakbay being subjected to.
Thank you so much for joining us here on the Ground Report. That was Tshepo Kgadima, our political analyst, just giving us a breakdown of the judgment that was passed down in the case between Bank Baroda versus Oakbay.